Next, we have Lord Hendy, King's Counsel, a leading, very well-known trade union law silk and member of the House of Lords. John, please.
Thank you, Pete. Like Shami, I feel a very great honor in sharing this platform with so many esteemed colleagues in defense and support of our very esteemed colleague, Rajiv Menon KC. Let me offer my apologies. I'm one of those who have to go to another event very shortly. I shall be short. Anybody who knows anything about my practice knows that what I know about criminal law could be written on the back of a very small postage stamp. But I do have some experience of contempt of court proceedings. Over the last 39 years, I've represented many unions and union officers who've been brought before the courts on contempt charges of defying injunctions for taking industrial action and so on. My role in this campaign has essentially been to try and galvanize support amongst the trade unions, and I'm very pleased to say that all the unions, which I've so far contacted, have written saying that they support the campaign and the statement that has been issued so far. I've copied all those to Rajiv. I'm afraid I haven't had time because I've been in the House of Lords today to count them, but I think we've got half a dozen so far, Rajiv. And I'm seeing the president of the TUC at a function later on this evening when I'm going to see what can be done vis-a-vis the TUC. So there is massive support, as indeed the attendance at this seminar shows. But the question, of course, is what is the object of the campaign and what can the campaign legitimately seek and ask people to sign up to and demand? Because we have to be very careful not to fall into the trap of it being said that we in some way have tried to influence the court proceedings. But it does seem to me that it's not that difficult for a campaign statement to express concern about the two principles involved here. One, the freedom and indeed duty of defense counsel in criminal proceedings to make the best speech that they can in defense of their client, and two, that juries must decide the cases according to their conscience. And if we express that concern without reflecting on the particular circumstances of Rajiv's case, I can't see that we can be criticized for that. I'm sure there are people better qualified than I am to draft such a statement, but I do think that that's what we need is to do that, because I understand that there's some reluctance in some quarters to express support for Rajiv's position for fear that it will in some way prejudice the forthcoming hearing next week. So that's my contribution, really, is to say, look, there is a way around this to campaign in the way that I suggest. I'm particularly concerned that the Bar Council, who've already made a statement through Kirsty Brimlow, the chair of the Bar, prior to the Court of Appeal hearing a week or so ago, I'm particularly concerned that Kirsty and the Bar Council should make some sort of a statement before the High Court proceedings next week. I wait to see. There are people on this panel who are better connected than I am to seek that support. But again, it does seem to me that there's no obstacle to the Bar Council saying we are very concerned that the freedom and duty of defense counsel to make whatever they think is the appropriate speech in defense of their counsel, so as long as they stick within the law, is at risk here, and that the principle that juries decide cases according to their own conscience has been the law for, as I understand it, for 300 years or so, is a paramount obligation. So I'm afraid that's probably all I can contribute, Pete, to this
Thank you,
this
John.
evening's event. Thanks for listening.